Good afternoon. We are quite surprised that yesterday senior ministers of the union government have taken so much of an effort to speak on the Supreme Court's presidential reference judgment, as you would call it, the advisory view that the learned court has put forward. The effort has been so much highlighted. It was all reported everywhere. I'm just taking a sample to show that they've gone on a very elaborate way to talk about what the Supreme Court has come up with. The BJP finds this again an attempt by ministers of the Union Cabinet. Earlier we knew even the Prime Minister himself was on board, commenting on another constitutional authority. Yesterday's press conference, in the light of the presidential reference which has come about, is again very clearly using this presidential reference comments from the court almost as though to forewarn constitutional authorities as to how they have to do their job. I think the cabinet and the BJP very clearly feels that there should not be any attempt. There should not be any attempt to interpret this very clearly laid out view from the Supreme Court to justify what is being done by the government. As the Supreme Court themselves have said, each case has to be approached distinctly on a case-by-case manner, and when questioned, the Supreme Court has the authority to go to look into whether a particular decision was fair or not, or whether it falls foul of Article 14 of the Constitution. But to again try and use it to give it an interpretation, or to use it to self-judge your own judgment or your own actions, is, I think, a wrong way of going about receiving the judgment which the Supreme Court has given in its advisory jurisdiction. The attempt by ministers, and especially, they have even gone to the extent of saying constitutional authorities in future will have to bear this in mind while discharging their constitutional function. It has very clearly been said by the ministers who spoke yesterday. Constitutional authority, I'm sure every constitutional authority in the country is performing its own job, and this judgment from the Supreme Court which has come in the presidential reference is very, very self-explicit. And for the benefit of all of our media and others, yesterday Sri Arun Jaitley had spoken about it in the National Council, and we are giving that in circulation for all of us to again understand what the Supreme Court has said in the presidential reference. But to have to re-infer it, to justify and also to forewarn authorities, saying in future you beware, you don't do anything that is going to be going against, this is the kind of viewpoint which has come up, I think is taking and stretching this presidential reference a bit too far. And I think, therefore, the central government should, the union cabinet ministers particularly, should refrain from using this judgment to justify whatever they are doing, even if they are doing wrong. Even if the inference that the Supreme Court decision has given, if you go by that, very clearly, when private operators are being given natural resources, scarce natural resources, it is expected that the method be of revenue maximization. The Supreme Court has very clearly said that. And the coal block allocation, therefore, which is not the subject of this presidential reference, but very clearly, and in the coal block, therefore, when you have adopted to give the coal blocks to private operators in order to maximize revenue earning, auction should have been the approach and the method through which this scarce research was supposed to have been allocated. So let us understand that on the matter of coal blocks, which was not part of this presidential reference, but now with the presidential references word having come from the Supreme Court, and when the coal block matter comes to here to be heard, it's very clear that when you went through private operators, the method should have been auction, because that's the only way in which revenue maximization would have been served. The Supreme Court in its presidential reference very clearly talks about it, and very simply and straightforward manner talks about it. I hope there is no attempt by the Union Cabinet Ministers to interpret the judgment in favor just so to justify their wrong policy decisions. As and when questioned, each case will be analyzed by the Supreme Court, and that's been made very clear yesterday, and therefore to use it particularly to malign or to forewarn or to caution a constitutional authority is an unacceptable and condemnable practice which the government should not indulge in. We wish to make that absolutely plain. Do not use this judgment to whip another constitutional authority. Every constitutional authority is doing its job, and if there is an issue, the courts are there to deal with it. That brings me to the next issue of the Prime Minister repeatedly telling us that the decision on the FDI in multi-brand retail is not being taken up under anyone's pressure. We understand that he is trying to tell us that it is not being brought in under the pressure of the United States or any other country. But it is strange, and it is time that a Prime Minister who in 2002 and again in 2004 had spoken against FDI had made a U-turn very recently. Prime Minister himself was against it. And the U-turn has happened somewhere between 2004 and 2010. I'd recall, and I'm sure all of you all will remember, that around 17th of November last year, the Prime Minister had assured that on multi-brand retail, the government shall not take any step until all the consultation processes are done and completely done with all the stakeholders. Have all the consultation with the stakeholders been completed, Prime Minister? How is it that suddenly you've changed your mind and brought this particular step in spite of that assurance that you had given us? That due consultations will happen with all the stakeholders. Where has that assurance gone today? And how come that the Prime Minister himself, between 2002 and 2004, even in Mumbai when he spoke to the traders, National Traders Association, when he had assured them that he shall not bring this in any hurry, suddenly has brought it in today? Can he please explain how the U-turn has come about? And if it was not under pressure that he is taking this step, what explains, in fact we've not had an answer from the government, what explains US Foreign Secretary Hillary Clinton going and meeting Mamata Banerjee in the context of FDI in retail? We've not heard an explanation as to what was the meeting about. Are we having in this country a precedent where a foreign secretary from some other country comes over and directly interacts with the chief minister who only a few days before that had objected to FDI in multi-brand retail? So the Prime Minister actually owes an explanation as to what compulsions under which, in such a hurry, FDI in multi-brand retail is being brought in. I remind you again, Sri Advani ji had mentioned very clearly, and it is the truth, that in the New York City, even today, Walmart's big stores are not allowed to operate. Whereas here in our country, we are in a rush to bring them in and have an impact on our manufacturing sector jobs, on our self-employed traders. We have repeated, both in the political resolution and in the economic resolution of the BJP's National Council meeting, which was held in Surajkund, that we shall absolutely oppose this hurried step. The BJP is not anti-reform, but at the same time, the country can't be misled that Walmart or any other group is coming here to build your cold chain links or to give you the last mile connectivity to the villages, nor are they coming to improve the better of the farmers or our small traders. They are coming to have their profits made. Having procured internationally at a cheaper rate, they are coming to utilize our domestic consumers. Are we throwing open the whole system in such a way that we are not even going to offer any protection for the self-employed people of this country? The growth story of UPA has been jobless. I think they have no moral right to take away the jobs of the people who are self-employed. The BJP would like to remind the Prime Minister that he please does not hurry into this whole matter under the pressure of anybody. Thank you. Very clearly, the BJP is playing its game as a tool in the hands of the ruling Congress, where evidences are available and where very clearly the cases are almost open and shut kind of a case. You find, as you're quoting, Sachan's murder case, we knew the NHRM scam was one of the biggest the country, and many of the facts had already come up in the open and people knew about it. In such a case, you see how the CBI misuses its position as a prime investigation agency and builds a case which is not going to bring the truth out. डॉक्टर सचान के विषय बोलने के समय मैं ये कोशिश कर रही थी, मगर ऑफ कोर्स कुछ और क्वेश्चन के लिए जवाब देने के लिए शिफ्ट हो गए हूँ. सीबीआई जहाँ केस है उसको पानी फैला करके सच्चाई बाहर आने में से पता नहीं कैसे कोशिश कर रहे हैं कि उसको दबाने के लिए, और जहाँ पॉलिटिकल इंस्ट्रूमेंट के टूल बन रहे हैं, कांग्रेस के मिसहैंडलिंग के लिए उपयोग में आ रहे हैं. आप अमित शाह जी के केस में देख रहे हैं, एफआईआर एक जगह फाइल हुआ है और चार्जशीट दूसरी जगह, और उसमें भी नाम जब मर्जी डालो जब मर्जी ना डालो. अमित शाह जी को फंसाने के लिए हर तरह कोशिश हो रही है, पहले से लगातार कोशिश होते रही है, और आज ये भी कोर्ट में ऑब्जर्वेशन के नाते कोर्ट ये बात भी बोले कि सीबीआई को पता नहीं चल रहा कहां एफआईआर है, कहां चार्जशीट फाइल कर रहे हैं. सच्चान के केस में जो क्लोजर रिपोर्ट बना रहे हैं, जिससे पॉलिटिकल फेवर एक तरफ से पार्टीज जिससे उनका अलायंस बरकरार रखने के लिए होना है वो एफर्ट हो रही है, और इस तरफ पॉलिटिकल ऑपोजिशन पार्टी बीजेपी के सीनियर लीडर्स को फंसाने के लिए जितने भी कोशिश हो रही है वो हो रही है सीबीआई के द्वारा. सो अमित शाह name being given in Tulsi Prajapati case is a classic case of misuse of CBI. I am trying to believe that, but the instances that I've quoted here to you just a minute ago, 2002 and again in 2004, the Prime Minister Dr. Manmohan Singh himself had stood up against FDI in retail. There are record and evidences available for all of us to speak and check up. And if in the national meet of traders, the Prime Minister in 2004, Dr. Manmohan Singh himself had said that he shall not be in favor of FDI in retail, what has brought out this U-turn in the Prime Minister's position? One. Then In November last year, 17th November last year, the Prime Minister himself had assured the country that unless consultation with all the stakeholders are completed, FDI in retail multi-brand will not come in. Has that process been completed, Prime Minister? None of us seem to know about it. So what brought the change again? It is for the Prime Minister, therefore, to explain. And third, and equally important or more important, is when you have a Foreign Secretary of the United States, Hillary Clinton herself, come in and meet the Chief Minister, that Chief Minister, who a few days before it had objected to FDI in multi-brand retail. Tell us what pressure then is working. How could a Foreign Secretary and go directly meet with the Chief Minister and attempt probably to convince her not to raise an objection on FDI in multi-brand retail? So when its alliance partner, whether it is Mamata Banerjee or Mulayam Singh, have all been against it, with what hurry and under what pressure is the Prime Minister bringing this in? That is something which the Prime Minister has to answer. Aren't we very clearly saying that 2 times when the Prime Minister has staked his all, one during the nuclear treaty and now again on this matter, he has to explain as to why he has changed his position. So we are certainly asking him as to why have you done a U-turn? As to how come that the Foreign Secretary of US comes and meets the Chief Minister directly? Explain it all. Otherwise, this introduction, however much now, after an afterthought, the Prime Minister may say that he is not doing it under any pressure, does not hold good. His explanation does not carry weight unless he explains his U-turn, unless he tells us why Hillary Clinton had to go directly to Mamata Banerjee, and unless he tells us why, in spite of Mulayam Singh Yadav and Mamata Banerjee, both of whom till Mamata Banerjee till recently an alliance partner and Mulayam Singh ji till today a partner, have objected. And if in spite of that, in an alliance government, what is the justification for this bringing in a hurry, or as it were, an overnight decision as it were? So it is for the Prime Minister to explain. His U-turn, Hillary Clinton's visit, 17th November last year's assurance, notwithstanding, you are insisting on bringing this now? Tell us why. No, I'm not sure I understand your question. The Supreme Court's judgment, which has come 2 days ago, is on the matter of a presidential reference which the government went as regards allocation of scarce natural resource, asking specifically 8 questions. This particular court case, the court reference for which decision has come day before yesterday, based on which you had the cabinet minister sitting and talking, was post the 122 license cancellation by the Supreme Court, the Raja matter, in which the licenses being cancelled was very clearly pronounced, post which, as regards the methods of allocating natural resources, the government of India, through a presidential reference, went to the Supreme Court to seek answer in an advisory jurisdiction of the Supreme Court on specifically 8 questions. So I'm not sure if there is a link between this one and whatever you're referring to. I'm not sure I will agree with you, because there is a very big mix-up, if I understand the issue that you're raising. After the cancellation of the 122 licenses, there's no review. In fact, yesterday's judgment very clearly says that it will not comment or review on it, and therefore, so unnecessarily, I think I have to understand you better. You have to explain your question better, much before we get into a situation where we are talking about something on which I'm not at the position to understand. So I'm sorry, you may have to explain your question better. I wish you show me the copy and I'll certainly respond. The presidential reference is not on this issue, and I'm sorry, I'm not. On the natural resources allocation, the Supreme Court judgment also says that it is not a rule, it's not a constitutional principle. Isn't that what the Supreme Court judgment is saying? Where is the contradiction, therefore? The Supreme Court judgment in this particular advisory which has come out says when there is a commercial interest which is being the objective with which you are pursuing something, and when private operators are involved in it, revenue maximization and auction being the best practice would be suggested. But when it is a matter related to social welfare and for other welfare considerations, any other method, any other non-auction method may be adopted. That's what this judgment says. So where is the contradiction? And even while doing so, when it is for social welfare related principles, when non-auction methods are being adopted, the objective will have to be stated and very clearly the reasons will have to be recorded. That's how far we have understood the judgment, on which, of course, yesterday we have even distributed a note, which you're very welcome to take a copy of again, and which is what Shri Arun Jaitley explained in our National Council. So there is no, I don't see a contradiction anywhere.